Hi, I'm Sarah Winfrey, and I'm a family planning advisor with Coastal Funeral Center. Today, we've invited a few of our community partners to talk about trusts. This series is meant to help answer frequently asked questions about financial planning, trusts, and wills. In this video, we're going to be talking about Trust 101, Trust versus Wills. Today, we've invited Seth Bier from Bier Law in Redondo Beach to speak with us. Thank you, Seth, for joining us today.
Well, thank you for having me, Sarah. It's a privilege to be able to be part of this series you're providing for our community.
What is the main difference between a trust and a will?
There are a lot of differences. They're both great planning instruments for different scenarios. In estate planning, that's what I do. We plan for, I call them life events because it's not that fun to talk about, but basically we're trying to help people plan for the possibility of being incapacitated or the eventuality of them passing away. A trust allows people, when they transfer title of their assets into the trust, to plan for both incapacity and death. A will is only planning for death. So they serve different purposes, and for some people, couples, a trust works better, and there are certain scenarios where a will is a better instrument.
So I wouldn't need just a will. There's many more components to a will than versus a trust.
Most of what we do, or planning that we do for clients, are comprehensive, more modern type of packages than what typically was done in the past, where people would just get a will. So if it's a will-based plan, they'll get a will, but they'll get durable powers of attorney. That helps with incapacity planning. And also healthcare documents, advanced healthcare directive and HIPAA authorization. So it's a complete package. When you get a trust package, when that's the main instrument you're going to use, you actually do get a will that works hand in hand with the trust. It's a safety net for items, assets that aren't titled in the name of the trust. When someone passes away, you can use that to get a court order after they pass away to get it put back into the trust. So there's a lot of different pieces depending on, it's not just what assets somebody has, but what they want, what's important to them and their families.
So who would be eligible for a trust?
It really does depend on the people I'm sitting down with, their concerns, their goals, and their assets. And in our state, if your estate is worth more than $184,500, and that number is going to change probably soon, and I have no idea where they get that number, you have to go through probate, whether you have a will or not. If you use a will as your main instrument of planning, you have to go through probate. Probate actually means to prove the will. It's a process in California most people try to avoid if they can. If you use a trust as your main instrument, you can avoid probate. So it's one of the greatest advantages. So for folks who have an estate worth more than that magic number of $184,500, if they're homeowners, chances are I'm going to end up recommending a trust-based package versus a will because they want to avoid all the different issues that arise with probate.
That's such valuable information, especially for our families. To a trust, what information do I need to gather before I meet with someone?
I just get very basic information about their families. It's really the conversation I have with them, learning, but their goals and concerns, because everybody's different. Even a couple who think they have the same ideas of what they want or what's important to them, they differ. And so gathering all that sort of information, then looking at the assets and seeing what they hope to accomplish if they want, because with a trust, even with a will, you can decide how your estate's going to be handed out to the people, your beneficiaries, and you can really decide who gets what, when they get it, how they get it. So these are all components that get built in once you really learn about what's important to the people you're dealing with.
When we ask is one better than the other, really they have different functions for each other, and one kind of goes hand in glove with the other. What would you say for someone about to enter the process? Do they need to talk to their family? What would be their next steps?
If I was talking to them, I'd prefer to sit down with them and have a conversation, sort of lay out all the different options they have. When we do, we'll meet with somebody, have our personal planning session with them. Really, I ask a lot of questions to gather as much information as possible, answer their questions, and then let them know the different pieces that they need to fill in, because they're going to have to choose all the different, who's going to be a trustee if they can't do it, all the different positions that need to be filled once they aren't able to handle it themselves anymore. And then we send them on their way for usually about 2 weeks to talk with their family, loved ones, whoever they want involved or whose opinions they want, to really consider all the different options and talk to them. Because we have people who come to us and say, I'm going to name my brother as a trustee. Have you talked to him? No. That's not a very good plan. You're just looking to add problems instead of solving them from the beginning.
Absolutely. What would you say would be the perfect age for someone to start thinking about planning?
18.
18.
Now, okay, you might not have the assets necessary to plan, but I think be under scope a little bit, but everybody over the age of 18 should have an advanced healthcare directive. And if they have even a bank account, a financial power of attorney is important because parents think, my kid's 18, they move out of the house, they go to college, whatever it is, they're getting their first jobs. If something happens, God forbid, they're in an accident, they can't speak for themselves at that point. The parent can just make medical decisions or go to a bank or talk to a college. They can't.
Wow.
Legally. Now, sometimes there's leeway. People will, in a horrible situation, hopefully help the family out as much as they can, but legally they can't. So these are really important documents. A will, most of our will-based plans are usually for younger families that don't own a home yet or just starting out. A will's the only place you can nominate guardians for your minor children.
Oh, really?
So that's something to accomplish with a will. And once they have more assets, in our state right now, the way probate is, it's very expensive, it's very time consuming. You can avoid it all using a trust as the main instrument. So
this is such valuable information. What would be one piece of information or advice that you would recommend telling someone who is just about to go through this process?
I think if you're going to start delving into this world, it's watching videos like this and hopefully finding an attorney or an advisor who can educate you, because there's a lot of misinformation or a lot of old information on people's websites if you go on the internet. So I think education is the most important thing. So that's why this is so important. If they're going to start, have an understanding, learn some of the term. You don't need to be a lawyer, you don't need to learn legalese, but having some idea of the terminology, the difference between a trust and a will, that's a big deal. And we sit down with a lot of people. Even after our seminars, I'll say, okay, I'm ready for my trust package. And we'll say, let's go through everything. They don't need it. They don't need the trust. And a trust is going to be a lot more expensive up front than a will. Usually on the back end, a will becomes more expensive because of probate. But education, I think being informed is the most important thing somebody can do.
Thank you again, Seth. This has been so informative. Now, if someone wanted to get a hold of you to learn more and how to set up a time with you, what would be the best way to get a hold of you?
I think our website is a great place to start. It's bier-law.com, so bier-law.com. Or you can contact us through email on the website. Our phone number is 323-999-1230 for folks who don't want to deal with computers and the internet. Our website, we have an on-demand webinar if they want to jump ahead and start getting that education and become a little bit more informed. We offer, if anybody watches that, a free personal planning session with me afterwards. We can sit down and whatever they learn on that, we apply it to their personal situation, and they can ask me lots of questions and go through.
Thank you again, Seth, for joining us. And thank you all for watching us. If you have any questions and would like to know more about Coastal Funeral Center, please feel free to call us at 310-326-6343 or visit us at our website, coastalfuneralcenter.com. Thank you.